This presentation looks at the history of occupational health and safety. It will focus on the factors that have influenced the development of the related laws and the current work health and safety legal framework in Western Australia. We will now look at the history of occupational health and safety. The concept of looking after one's health and safety has been around since the beginning of mankind. A caveman needed to risk assess to determine safety factors prior to going out hunting, climbing a tree to pick fruit, or even picking a cave to sleep in. The oldest known written document of an entire body of laws is the Code of Hammurabi. This is a document of 282 laws or rules written in Babylonian times at about 1780 BC. There is evidence in the Code of rights and responsibilities of people conducting business, including the right to get paid and liabilities to be incurred if work is not satisfactory and injury or damage occurs. The Code of Hammurabi is evidence of the increasing influence of centralised government on the personal and professional lives of the general population in ancient Babylonian times. The Industrial Revolution, commencing in the mid-1700s, was a turning point for economic and social change for the working class. At the beginning of this period, labour was heavily provided in many industries by children. Working conditions were poor, and there was much abuse towards the workers. The Industrial Revolution resulted in concentrated workforces around areas including mills, factories and mines. This gave rise to organised groups fighting for workers' conditions. This was the beginnings of the trade union movement. Strike action was the most commonly used method of workers getting what they wanted, and laws started to come into force which gradually improved the conditions of workers in England. In 1802, the Health and Morals of Apprentice Act in England was passed. This was designed to protect the abuse of children at work. The Health and Morals of Apprentice Act gave rise to other acts which were formed to help protect workers' rights. These acts were consolidated in 1878 and became known as the Factories Act. These acts were then applied to all trades. European settlement in 1788 brought the precedents of English law, which was primarily set within the Factories Act. The English enacted their laws in Australia, and these were enforceable in this country. Australian experiences over time have created the precedents that have changed the laws that apply today. The World Wars, especially World War II, changed the face of the Australian workforce. More people were actively employed, and many more women started working. The trade union movement aimed at improving workers' conditions. This started developing in Australia from about 1850 and grew significantly. The trade union movement supported socialism, and over time strong affiliations were formed with the Australian Labor Party. Prior to 1985, occupational health and safety in Australia was considered to be the following. The Robins Report was a major English document presented in 1972 by a Safety and Health at Work Committee. This committee was formed to review the provision made for the safety and health of persons in the course of their employment, and to consider whether any changes are needed. Some of the main findings of the reports are listed here. It took many years for the findings from the Robins Report to be translated to occupational health and safety law in Australia. Major changes to Australian approaches to occupational health and safety occurred in the years following 1985. This was due to a number of factors that are listed here. It was during this period that many of the changes recommended by the Robrins Report were implemented in Australia. The National Occupational Health and Safety Commission was a tripartite body formed in 1985 and had representatives from government, industry and unions. The National Occupational Health and Safety Commission developed national standards and codes of practice for many occupational health and safety areas. These national standards and codes of practice were not legally enforceable, and there were differences in the way that they were adopted between the states. Have a look at the first picture. This is a famous photograph by Lewis Hine. It shows construction workers on their lunch break in the early 1930s. Look at the lack of safety equipment used. Now have a look at the next photo. This is a photo of construction workers today. You can see the adoptions of safety procedures and equipments. This is a great representation of how far we have come. We are now going to look at occupational health and safety framework in Western Australia today. Australian law is based on the English common law system and has developed over the years, such that there are now a number of sources of law in Australia, including statute law, common law, constitutional law, customary law, and international law. Occupational health and safety uses primarily common law and statute law sources. In the common law system, a judge's decision in a current case is influenced by the decisions of cases that have been settled previously. Before deciding, a judge analyses the similarities of the previous case to the current case. Common law evolves over time as new decisions are made by judges. The new rules become precedents for future cases. With statute law, Parliament and other authorised bodies make the laws, hence this becoming legislation. These laws authorise, forbid or state something. Some examples of delegated legislation are acts and regulations. Statute law is more prescriptive and takes priority over common law. Current statute law in Western Australia has taken common law precedents, such as duty of care provisions, and embedded this into the legislation. The occupational health and safety legislation has changed dramatically in recent years. It has moved from a prescriptive focus to a consultative approach. All stakeholders in an organisation take part in issues relating to health and safety in the workplace. Occupational health and safety legislation imposes duty of care in the workplace. This requires adherence to a standard of reasonable care while carrying out any acts that could cause harm. Negligence must be established for a successful legal action against a business. The following is a diagrammatic representation of Australia's health and safety legal framework. Compliance with acts and regulations is mandatory. Compliance with codes of practice, standards, and other materials, while not mandatory, will help a business to support a due diligence defence to a charge under the Occupational Health and Safety Act or Occupational Health and Safety Regulations. An Act is a law made by Parliament and enforced by government departments. Occupational Health and Safety Acts are legal rules that govern workplaces to ensure that workers are free from injury or illness at work. Non-compliance to these rules is an offence. Each state and territory has a Principal Occupational Health and Safety Act, which sets out requirements for ensuring that workplaces are safe and healthy. Western Australia follows the Occupational Health and Safety Act 1984. Occupational health and safety regulations are rules that are adopted under state and territory Principal Occupational Health and Safety Acts. Regulations are legally enforceable and serve to give guidance to specific requirements of the Act. They are usually made in relation to specific occupational health and safety issues, such as working in confined spaces, working at heights, or working with dangerous chemicals. Not complying with regulations is considered an offence and can result in a fine. WA legislation is followed by Occupational and Health Safety Regulations 1996. The purpose of guidance material is to provide advice on how to meet regulatory requirements and aid in hazard and risk control. These are not legally enforceable, but can be used in courts as evidence that legal requirements have or have not been met. Examples of guidance material are listed here. Standards should be assumed to be the minimum regulatory requirement. Some standards, for example, working at heights, have been incorporated into occupational health and safety legislation and is now legally enforceable. The Australian Commonwealth, states and territories are responsible for enacting and administrating their own work, health and safety laws. Each body has their own regulator, who is responsible for overseeing compliance with their occupational health and safety laws. The regulator in Western Australia is WorkSafe WA. In 2008, an agreement was made by state and federal governments to implement model legislation in order to achieve national harmonisation of work health and safety laws. A Model Act, model regulations, model codes of practice, and a national compliance and enforcement policy were all agreed to. In 2008, the National Occupational Health and Safety Commission was replaced by SafeWork Australia. SafeWork Australia was responsible for developing the model legislation. SafeWork Australia recommendation for the model legislation includes the following. The Western Australian Government has stated an intention to introduce a new Work Health and Safety Bill in order to align closer with the legislative principles set out by the Model Work Health and Safety Act. The plan is to introduce the major recommendations of the model legislation with four main areas of exclusion. The planned exclusions areas are listed here. Further information regarding this can be found on the WorkSafe WA website. The preceding presentation has shown the history and legal framework of occupational health and safety in Australia. The following major incidents and accidents have occurred over time and have helped develop our laws to what they are today.